if a lawyer were to bring up these questions instead of just Robbie, that judge would be pursuing getting them thrown out of the bar by this point.
Yeah. Oh, for sure.
And probably successfully so.
And they all must get wind of that somewhere. They know it. You know.
Well, I bring that up.
There's a long history. I mean, there is a history of challenging this information process and all that. And it's out there, so I imagine they discuss it in some way.
Well, and it's exemplified in the anti-government movement handbook, you know?
Uh-oh.
That I bring up in this hearing.
Sorry. Technical difficulty. Are you there?
Yep, I'm here.
Technical difficulty is over. Sorry, go ahead.
Okay, so what I was saying is that is exemplified in the anti-government handbook when they talk about the judge who ruled in favor of one of these sovereign citizen people and then subsequently lost their job.
Oh, yeah. Yeah, I gotta get that story and save it, man. That was a good one. All right, here we go. More of the break.
Right, wrong, and different.
Yeah.
Sherman's reporting, right? West Ridge. That was directed at Sean. I shared over Yes. Because Lucero, her warnings outstanding. Yeah. Okay. And then the other ones were.
It's just like lawyers talking among themselves. We can't hear Robbie or anything.
I'm gonna switch networks. I'll be right back.
Okay.
You have to call John Cotton. John Cotton, bitch. I like the I like that. His first because he had a trial first on good defense attorney. I can't remember what his name was.
Wait, don't we have to invite him back in?
Gary?
Yeah. Or no, wait. Will he still be able to see and join this call?
I think we may have to invite him back in or call him back.
Yeah. Well, he'll text me and let me know. I don't know.
It says he's available now, so he might have gotten back on.
Oh, okay.
No, these two are sex abuse cases. No, gosh, I can't remember his name. I want to say it's sort of like a D last name. I kind of played the whole, like, I don't know what I'm doing, but it was actually, like, true. No, he was a good defense attorney.
Jenna, is there any reason why I cannot take the rule and present it?
Okay, so action. You go, Jenna, is there any reason why I can't take the guilty plea? And so now she's going to trip over herself to try and help you do that.
Yep.
No, you absolutely can. The state offer remains open. This I can discuss. Offer was
I believe it's 8 hours of community
it was 8 hours of community service.
8 hours of community service is still on the table, Robbie?
Yep.
Oh my God.
They've tried to threaten me as though they'll take it away, but they never have.
I know. That's why I'm surprised it's still on the table, because I heard all those threats. I remember them, and it's hilarious that it's still on the table. That was all nothing but a bluff, and you play poker. That's hilarious. Oh my gosh. So, oh man. All right, here we go.
It was yeah, and then I talked to Brendan, so there's no possibility that's
I can't hear anything either.
May I have the bar number of any attorneys present? I'll get to the court.
Since I'm the alleged defendant, am I a member of the court?
You're ready for the judge?
I think so.
So you asked for the bar numbers of the attorneys in the room.
Yeah, I asked for I wanted all the bar numbers of all the attorneys in order to procure them as witnesses.
Nice.
And then she said something about blah, 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 members of the court, and I asked if, since I'm considered the defendant, does that make me a member of the court? And she just kind of laughed and said she doesn't think it works that way.
Okay, yeah, I wanted to make sure that's
But
what.
what answer?
Yeah, basically.
I mean, weasel words, right? Because, I mean, I've said before, when they say the court finds blah, 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 they're dragging you along. They don't say the court, what people of the court, find. Because really it's the judge trying to make his opinion seem like the opinion of a huge group.
Oh, yeah. This is so weird. This is how, children argue when they get in formal settings like this. I mean, she is basically saying...
everybody knows you're a big poo-poo head.
Oh, yeah. Oh, yeah. This is how they, it's like, you know what, buddy? I hear you talking to me and say, fuck you. I mean, in so many words, that is exactly her attitude. That is what comes out of her mouth. Of course, it's in an acceptable way. But that is it and only it. And yet she doesn't have a dog in this race, right? She has no dog in this fight. Oh, yeah. Pretty funny.
Here's how we judge about
Oh, yeah.
question. Well, yeah, you can counter after, probably after
Those people from another case talking.
after she gets done with these last remaining matters.
Thank you.
I would assume that it's your responsibility to correct the record when the judge in the case.
That's what I don't make the determination as to the processes. I mean, that's ultimately the judge.
Interesting question I'd like to discuss just now.
Cool.
So he points out that it is the prosecutor's obligation to make sure the prosecution is handled in a just manner, right?
Mm-hmm.
So even if it's the judge's problem, the prosecutor is supposed to be fighting to make sure the judge doesn't botch up prosecution by creating an injustice or anything like that.
Yep.
Right. So Robbie was pointing to that very factor right there.
Yep.
Is it your obligation to make sure that the judge doesn't leverage an error that's a known error out into further injustice or whatever? I mean, he phrased it. I'm going further than he probably phrased it at the time. But anyways, the fundamental is the same. And you hear her saying, hey, judge's determination, right? Because their whole mentality is built upon, it's not about right and wrong. It's not about reality and fiction. It's about getting that judge to flip a switch for you, to say, hey, I hereby grant you whatever I want, whatever you want, or whatever. And so, again, this whole, the difference, he's giving her the opportunity, pointing out that she should be clearing up and not letting the judge make mistakes, leverage those mistakes to her favor, because ultimately it's supposed to go against her. It's supposed to, it's supposed to. It's, the public relations would hold that her allowing that should sabotage her case later on. We know it won't. They know it won't. That's why they're not worried about that.
Yeah, of course. Robbie,
Yeah, and
go ahead.
I asked her that because I wanted to give her the opportunity to stop engaging in criminal activity and start doing the right thing. I wanted to give her the fair opportunity to do that, but she, of course, declines.
continue.
All right.
Just out of curiosity, do you stand up for this? Not that it matters.
I was already standing.
Oh, gotcha.
Review the document in favor of counsel.
I have reviewed.
We look off in order to make a decision, final on whether you wanted to represent yourself or whether you wanted to request a court-appointed attorney first.
Okay, may I make one clarification before I threaten with again? No. Okay, do I have the right to assistance of counsel that is not licensed silently?
So he asks if you have the right to remain silent, right?
No, he asked if he had the right
correct?
to assistance of counsel that isn't the plaintiff.
Awesome.
Yeah, he punched him right in the mouth with his one clarification that he was able to squeak out of her before more threats. That's why I'm laughing. So I was putting it on pause there because it's just an interesting choice. I mean, it's ballsy. You just, right after a threat of violence, hey, before you threaten me with violence, and you just punch her in the mouth with the very issue that she's trying to dodge, which is what caused this threat of violence in the first place. They need you to check this box about the assistance of counsel, and you just hit it right.
Yeah, because you're essentially saying, hey, tell you what, I'll take a lawyer as long as it's not a bar member.
Exactly.
Oh,
I'm trying to comply.
So, and does it do their? And of course, they're trying to put in the requirement of a bar member that doesn't come from anywhere. It doesn't come from inside the forms and stuff like that.
Right.
You know, they're just saying, oh no, our approval is necessary. They're leaving it vague. You have to get the court's approval, and we all know what that approval is. You know,
the button we push is straight up. What is it? Fifth Amendment with the assistance of counsel, or I can't remember. Fourth, fifth, or sixth. It's one of those. Anyway.
And it doesn't mention. I mean, at the time there was no contemplation of the idea of a bar association. Right. That's a later.
Right.
That's a later habit at best.
Totally.
That they wanted to curtail people's abilities to only being a pre-approved list.
It really
pre-approved by them.
Preventing people from defending themselves by requiring that in order to get help, it has to be our kind of help. Otherwise, it's no help.
It has to be help that we can actually disbar.
Yeah, that we can threaten, that we
can get fired.
Yeah.
Ultimately, it means that the judge can get your guy fired.
It's the most
leveraging
crazy.
their position.
So, you just compare it to any sporting event on the planet, and you see, oh, yeah, that's fair. Yeah, that's totally fair. That's how it should be done. Oh well. All right, let's see how she responds, I guess.
You have the right to hire your own attorney.
Now, of course, that is a complete dodge of the question.
Yeah, talk about hearing only the. It's almost like her brain isn't able to comprehend the rest of the sentence.
Oh, I know. I think she knows the ethical argument there, and we're just playing word games and dodging, and she's got all the power while this is happening. I don't know. Is it any more complicated than that? Am I missing something?
Nope.
The public defender agencies from which we draw on for court-appointed attorney are not affiliated with the state. They're independent nonprofits.
Oh my gosh. She's in the
as if the profit or nonprofit status is a question.
Yeah. It is non-affiliated. Okay. As if it's a separate entity, therefore ethically it's okay, and there's checks and balances of power and total separation.
Again, a complete dodge to.
Yeah.
They're saying that we have a pre-approved list.
Right.
I don't care about what went into your decision-making process about the pre-approval process. It's a pre-approved list by the opponent.
Yes.
By the adversary.
So then, to clarify, do I have a right to assistance of counsel that doesn't come from a pre-approved list from my opponent? I mean, how much more? Because it's just, when it becomes so blatant, you could be Columbo himself and ask the best clarification possible, And it wouldn't matter. They'll still just answer whatever the hell they want.
They'll hear, yeah, she heard a different question. She heard, can I hire from the attorneys what one I want?
Yeah. So then it's like, okay, it's pointing out that tactic. Like how they're using it over and over and over again. It's being, it's disrupting the proceedings. It's preventing the efficiency of matters of justice moving forward, blah, 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 right? Could you please not do that as a matter of professionalism and courtesy, and then pop right into your next yes or no? I don't know. It just feels like it's got to be addressed because she's using it over and over.
Yeah, and I'm going to try to tamp down on that.
Oh, yeah. You clamped down quite a bit here. Here it comes.
There is a system called the Oregon Public Defense Services Commission, which is signed by statute to manage various affairs of court-appointed attorneys.
Signed by statutes and manages the affairs, what?
But the attorneys themselves are not employed under that system. They're employed as either their own independent attorneys or under the non-independent.
Non-independent what? I can't even... She mumbled off nothing because she knows she was rambling nonsense. I didn't even make that out.
Yeah, she knew she needed to say something to have pretended to address the question.
Right.
But she knew she couldn't address the question in any meaningful way.
Let's just
so she just word saladed it at him.
Yeah, I won't answer, I'll just describe. Okay.
License by the plaintiff.
They're not licensed by the state bar, Oregon State Bar, which is a non-profit.
Right, so they're not licensed by the state board.
She says non-profit, but doesn't that term, non-profit and profit, only applies to corporations and like civilian structures. This is government. Is
there such thing as a corporation in a state that isn't licensed by the state to do business in that state? That is, I mean, try doing business as a legal entity in a state without license from that state. You'll discover real quick that that's not permitted.
Right. So,
but I mean, she's dodging this question by kind of implying that they're not licensed much by the state. They have a lot of autonomy.
But see,
and it's like we're not concerned with enough autonomy. We're asking very specifically. He's asking very specifically. Can I get an attorney? Can I get legal representation? Because now they keep moving it from that to attorney. But can I get legal counsel that is not in any way licensed by the state? And she couldn't answer.
And further, when you look at the answer that she does give, and it's telling, she attempts to establish and just comes up with this stuff even though you wanted to know nothing about it. Establish that there is a illusion of a separation, because that attempt to establish a separation points to the fact that she knows this is a relevant ethical dilemma. And so she's attempting to resolve it. I mean, if you had no merit or anything there whatsoever.
She's attempting to make it go away.
Yeah. But the manner in which she tries to make it go away makes me believe that inside her own head, she knows there's a problem there. She could try any number of counter tactics. I don't know, it's weird.
They are not, their authority comes from the statutes of the state of Oregon, but they are not directly licensed by the state in the sense that it's the plaintiff through the attorney's office. They have nothing to do
I like how she added that in the sense. Well, she realized she was why, and then she added it in the sense.
And the governor have nothing to do.
I'm all trying to pause it and getting all fumbly with my fingers.
Sorry about that. Yeah, you notice how she discovered mid-sentence that if she left it there, she would have lied, right? Which is surprising. Normally, they don't much care about that. But she then said, in the sense that the prosecutor licenses them. Who said in the sense that the prosecutor, where is that added? She had to make it absurd.
Yes.
Because otherwise it'd be a lie.
Yes. And you hear that a lot in these things with Robbie. They add at the tail end something that negates the whole sentence from anything meaningful.
Right. She says they're not licensed by the state. Oh crap! In the sense that the attorney licensed it, the prosecutor,
Right. So it's
like
just,
what? Who would have contended that they're licensed directly by the prosecutor? We said by the by the adversary or whatever you said there. You didn't say specifically like that guy, particular personal approval.
no doubt. See, and these are moments where if her superior judge, right, who is motivated as bigwig judges are to keep the status quo and be brutal, blah, 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 like they do, if they were listening to this, these are moments where they would be going, oh, for fuck's sakes. You know, like the judges screw up too. We can cause those screw ups to happen. These aren't even people who are worthy of respect, of having a strong intellect or a quick wit or having a clever anything about them. They're vulnerable.
I just thought of why she cared. Oh, sorry.
No, I'm done.
I just thought of why she cared to make the adjustment instead of just leaving it to lie. Because the question on the table is, can I get legal representation that isn't? So she's actually needing to clean this one up a little bit, because otherwise it's like, great, I've got somebody in mind, you know.
Yeah.
Got a buddy that lives up the street that'll do just fine, right?
Yeah.
See, she needs it to be one of her pre-approved, licensed people, so she needs to adjust the answer to be yes. She can't leave an answer that is no on the table.
Right, right.
You know, no, you can have, meaning no, you can choose somebody who's not licensed. She needs to actually implement the requirement that it be a bar member.
Yep.
And that's why she's cleaning it up so nicely.
Pretty twisted. What'd you say, Robbie?
I just said, I see.
Oh, okay, here we go.
With licensing, well, it's in this sense, it seems you're differentiating between the prosecutor representing the state of Oregon and the state of Oregon, which licenses all of the attorneys in this. Well, I've explained to you sort of the different avenues of authority. The authority for government.
Oh my gosh, here we go.
And we're getting further from the question, sadly.
Yeah.
I mean, I know Robbie's, trying to pull that horse back and trying to get a good grip on it, but sadly that, we're out of the barn and trying to get back into the barn.
Comes from the Constitution. So, the state controls multiple aspects of our lives. So,
The state controls multiple aspects of our lives. Did you hear that?
That's interesting. I would make that itself a motion to recuse and vacate the entire thing. That mere statement right there.
Well, I'm going to rewind
She's just actually confessed a bias.
Yeah, no joke. And a strongly.
But she said our. She didn't say your.
Right.
She said our, hers included. So a confession that the state, that your adversary controls aspects of her life, disqualifies her to me.
Yeah.
But I know, it's all about, that's, you're not going to get much blood from that turnip.
So here it is again.
the state of Oregon and the state of Oregon, which licenses all of the attorneys in this. Well, I've explained to you sort of the different avenues of authority. The authority for government comes from statute of the Constitution. So,
She said comes from the Constitution.
the state controls multiple aspects of our lives. So,
The authority comes from the Constitution. The state controls multiple aspects of our lives.
Wow.
What the fuck?
I'm writing that one down.
That needs to go on a quote board. That's a t-shirt. My God.
And this is a supposedly independent judge
This is a fellow slave.
basically confessing that she already considers you guilty, which means not innocent to the state. You're not, that is basically saying you're not presumed innocent, because innocent means you're at arm's length to the opponent. It means that you're not considered controlled by them,
Right.
rightly controlled by them. She
You are still
just
your own.
confessed that you are not considered innocent. That to me deserves a whole, dissertation, so to speak.
Objection, point of
Yeah, smack on.
clarification. What multiple aspects of my life will this Constitution and the authority you're drawing upon affect?
Yeah, I agree with that. But I guess my point, or the point that I'm sticking on, is that that is incompatible with innocence. Innocence
Right.
means that you're not controlled by them.
She just said there are aspects of your life that you're not innocent to the state in.
Yeah. Controls multiple aspects of our lives. This is creepy.
And that she just actually also, I mean, you and her, there's problems with each. The our is horrible.
Yeah. It's
because
the worst.
she's saying that she is influenced by the state.
I know. They take this.
And
oh, go ahead.
hopes for benefits or hopes to be controlled nicely, right?
Mm. Voluntarily.
In essence, he's under duress.
Well, or vying for privilege, vying for benefits and favor.
It's so funny that they have to pretend their monopolized tyrannical system is basically voluntarism. They want that illusion.
Yeah.
Oh yeah, this is a voluntary society.
Yeah, because of Paine mostly.
Right.
Thomas Paine. Because of people like that, where they were talking about, ethics and so forth. That really took root in a lot of
writings, and now they have to deal with the
fallout of all of that.
When you go in there and act like a voluntarist would and saying, hey, where's the voluntary in any of this? Of course you get laughter and snickers because, I don't know.
That's just what we're pretending to be. That's like the town whore walking down the walking to her wedding in a white dress. It's like no one takes it seriously. We didn't mean it.
I've had her. All right, here we go.
All I've been attempting to do is ask for evidence that the Constitution and the statutes that I've used apply, and I have not seen any factual evidence of that. However, since you are threatening me by saying that I'll go into the cage by making a decision, I will submit this waiver to counsel.
Okay. I'll review it with you as I'm obligated to do so.
Oh my God. Here come a lot of yes or no questions that you can't possibly. So she goes, I'm going to review it with you as I'm required to do so. And I just know here come a slew of yes or no questions that are part of that waiver.
she's gotta clean up that threat of violence, right?
Oh yeah.
And make it act like you're free to answer whatever you want.
I've had them do this to me. I had them do this
to
me.
We have you now. Now we're going to get a series of lies that are to your own detriment out of it.
Right. And then when you object to being forced to lie, they were, oh, nope, this is over.
Oh,
next hearing, and they ran away.
I mean, is this still on the issue that she put to you where if you don't do this, you go to jail? Is this a subset of that, or is this a whole new demand?
No.
Are we upping the stakes, or is this still part of that?
This is part of that. Robbie said
No, I'm sorry. Let me try to clarify. Is this a new threat, or is this still the original threat? Is this the thing that he already checkboxed, that she's going over that he checkboxed, or is she going through a new list of demands?
These are a subset list of demands that go along with this signing of the waiver to the assistance of counsel.
But he already didn't he already do that under a threat of violence, or is this the thing that he's signing?
But once he turns that form in, she's going to have a lot of follow-up questions that she's got to.
No. That should be a new threat, is what I'm getting at. She threatened him. She said, "You go to jail if you don't sign this." Right?
Oh,
he signs it, and then she says, "Okay, now I've got A, B, and C that I'd like you to do too." The threat has been satisfied. I understand. You and I both know that the threat is still there. She will still throw him in jail if he doesn't answer these questions.
And that's what I'm saying.
Technically, the threat has been satisfied. You know what I mean?
Agreed.
So that's my concern, is that this is now, it's like they threaten you to go all the way to the end of the plank, but that last step is on you.
Yeah.
Right?
They're happy to see you go overboard.
Which technically actually was part of that whole ritual. No one actually threw you off the plank, as far as I understand. Ceremonially, it was, you weren't going to come back onto the ship is all, and you were choosing how twisted that is,
right?
To throw yourself, right?
And when this happened one time with me, and I was like, object to that question even being asked. It's none of the business. It's an invasion of privacy. I object to this one. Eventually it was, all right, we're done here. We're done here. And be quiet. And they put a new date, ran off the bench, and that was that.
Some of this is familiar, and I think I have heard this before.
Is it?
But, I mean, again, I realize, of course, you're dancing with jail.
Yeah.
But if you weren't dancing with jail, the very first question should lead you into a point of clarification that would lead into the whole box, the whole can of worms coming right back open again.
Oh, yeah.
Yeah, and at this point, I'm still afraid. So I wasn't as effective as I could have been. But.
Of course. You're not, I mean, realistically, you're not at liberty, so to speak, to ask any questions at this point.
Right.
She's already gotten out the sword.
I'm sure she considers the threat still in the air. It's all part of
Absolutely.
Successful...
And any rational person would realize that any fight right now can easily land you in jail. It's already been threatened. And this is just a part of what she's considering a part of the thing that she already threatened you to do or else, right?
Right. So, objection, point of clarification. Now that the threat has been satisfied, can I assume it's no longer in effect, yes or no?
Yes. Yeah. I mean, again, it's dancing with things, but, am I still under a threat of contempt to do what you're asking me to do? Okay, what is it you're wanting me to answer on each of these questions? What am I ordered to answer? Just you choose a yes or a no randomly, I don't care what. And she's saying then, I want you to choose the truth or what is true. Then it's like, well, I can't do so without clarification. I would be choosing randomly. You go down that, possibly. Again, your neck has to be your decision. But, the brainstorming would be, obviously, it's like, well, I'm caught between getting enough clarification to give you a true answer that I don't even want to give versus guessing and suffering the consequences of the lie you forced me to tell. And, again, I would now be considering a motion in to apologize for the lies that you put onto the record as a result of the threat of violence and the violence that you were under.
I love that. Apologize for the lies.
But that's true, isn't it? I mean, there's nothing wrong about what I said. You put something into the record for posterity, for everybody to read.
Yep.
As a result of this person threatening you with violence, that would mislead people to believe that these things you said, I mean, your word is to them, right?
Yep.
In a sense, people could mistake this for being something that you are putting your name to,
Yep.
And that would be something that would stick in my craw quite a bit. But again, I understand the threat of violence involved. I understand very well that you have to play, between safety and not shooting yourself in the foot, which is sad.
You can threaten me with violence all you want, Judge, but even if I do write down a name on this document, I'll just file a motion next week that'll apologize for having to lie to the court. So my question is, are you going to force me to make a claim and lie or go to jail? Is that part of one of these ways that the authority affects the multiple aspects of our lives, yes or no?
Yeah.
And again, testimony compelled under threat of violence, that's what this is.
Oh, yeah.
I mean,
that's
there
exactly
is
what it is.
a lot of past history on that subject of, does this court accept compelled, testimony or accept, testimony compelled under violence, threat of violence? Obviously it does, right? Because she herself forced you to do so.
Yep.
And accepted it, being fully aware, and you made her very aware of the threat of violence. You discussed it at length.
This tactic of forcing us to make claims and lies, and then state that, oh no, there's no duress here, this was voluntary, for a permanent record, is their main tactic. And I swear to God, it starts out right from the jump at the very beginning of everybody's, which is, could you please state your name for the record? Because if you don't have to do that, if you can exist as a human being without a name, certainly without a name that they can track and persecute you over, they're fucked. Their entire system is dependent upon, yes, my name is, this is my first name and this is my last name, because it's that name that has the social security card, the birth certificate, the driver's license, signature, and all that regular stuff they consider is what binds us. When actually, obviously, it's just geographical physical location. So this tactic of using crimes and lies, man, that sucker comes up a lot. Hidden, well
And what's
hidden.
the truth about your name? I mean, aren't you the one and only Joe Blow, right? It's like, well, I'm one of dozens of people using that name.
Yep.
It's like, heck, I know one personally who uses that name. So I'm not the one of anything. I'm one of many.
Yeah.
Am I the one you're talking about? Probably. But I'm not going to be the one to testify to it. And that's what they want. They don't want the burden to be on the prosecutor to specify that you're who they're accusing. They want you to accuse yourself.
Yep.
Are you the guy? Are you the guy that the prosecutor's trying to accuse? How am I supposed to know? Ask the guy who's trying to do it.
Yeah. Do you know?
Oh, well, everybody knows when they're the ones. Well, if it's so obvious, Judge, why don't you put it on the record?
I've only been here 15 times in the last year. I bet you recognize me.
Right. How about you make the assertion that I'm the one being accused instead of demanding,
Right.
under threat of, getting all bent out of shape and doing what judges do when they're bent out of shape, which is very dangerous for the rest of us.
Oh, no,
Sorry, I digress.
I'll tell you exactly what they threaten with. I do this at the beginning of all of mine, and when I pushed it all the way to the contempt charge, which is a go to jail, it was, all right, then I'll just put on the record that you weren't here and issue a bench warrant. Goodbye. Have a nice day.
Again, a lie.
Yeah.
I will put on the record that you weren't here.
Yep.
They're actually telling you they intend to falsify.
Yep.
They intend to make the record not reflect reality.
And then give a man with a
And to
gun
leverage
permission.
that into garnering violence against you.
Yeah.
And it's like, well, I was clearly here. What you're trying to imply is that I'm the one being accused. And that's the question at hand.
Yep. And that's just where it starts, and it's nothing but downhill from there.
They sneak around. It's like, no, the question at hand isn't whether I'm here or not. That's clear. I'll confess that I'm present. The question isn't that. The question is, am I the one accused? And the courts always try to get us to make that assertion ourselves, which is insane.
It is. It's self-sabotage, unknowing, if we aren't familiar with the nature of the hustle in it.
But what choice do we have, right? They put you into a situation where they know that you're going to be a problem right off the bat. The very first thing they do is try to get you to sabotage yourself in a very, very detrimental way, which is to relieve the prosecutor of the burden of accusing someone, pointing to someone and say, that is the guy I'm accusing. Because it could come back on them. It could be, there could be a what do you call it? A twin, right? You could be a identical twin. And then the prosecutor has actually, thoroughly done a misconduct. Right? Because you could trap them into that.
Oh, yeah.
That is the guy, I hereby swear that is the guy I'm accusing. Identical twin.
Yep.
Yep.
So they need you to say it.
They do. They need you to say a lot. And refusing to say it and just clarifying is what we do. It's why it causes them so many problems and why they make all the mistakes we're hearing here and why it's such a disruption.
But it's rough to come right out of the gate and have that argument. Because that's the very first thing. We haven't even gotten into anything substantial. They're wanting a confession as soon as you step in.
Mm-hmm.
That's, to me, kind of a real one that I don't want to give.
100%. That's the point here.
And I know, that's why Mark just says, you don't put your fight there. You go ahead and let them have that win.
Sure.
In a sense. And it's like, I hate giving them any damn wins.
Yeah.
Because they're basically hanging us on a bunch of small wins.
Yep.
Make us retreat. Yep. A little by little. And then we end up at sentencing and we're like, how the hell did they make me come here?
Slippery slope too, and they know it. It's just the nature of the comply or die. Which way are you going to comply? I mean, what I'm saying is, I don't ever think I've ever not complied. If I show up there, I'm complying.
Right.
I just am. Right. There is no...
And it's always
anyone to say, I don't comply, I'm free. Really?
Yeah.
Really?
It's show up at the courthouse, or we'll drag your ass to jail, and then you'll show up at the courthouse anyways.
Yeah.
Okay, well, I'll show up at the courthouse. Oh, walk in and announce yourself, or we'll throw you... It's that, it's always overwhelming response, overwhelming insanity as a result to you fighting the battle at any step, any individual step, and everybody around you is telling you, why don't you just concede that step?
Yeah.
Because that step isn't the big one.
They're all
you just retreat one little inch, right? You're just retreating 1 inch and going to court. You're just retreating another inch and telling them your name and telling them that you're the one accused.
Yep.
You're retreating one more inch and saying that that you plead not guilty or whatever. 1 inch at a time, all the way to that sentencing, because they know that they'll overreact to every fight. If you put up a fight about coming in, they'll overreact and go haywire. If you won't tell them your name, they overreact and go apeshit over the name thing. I didn't even know what the name thing was. I happen to have an uncle with the same name as me in the same town, and I one time over a ticket was trying to clarify that they had the right paperwork and everything. The judge went ballistic, and I didn't even know why at the time.
Gosh.
And that was my introduction to the name game. I'm like, whatever just happened, he was really upset about it.
Yeah.
And I was just saying, I'm sorry, which Gary are you? Could you clarify what Gary you're referring to?
Yeah.
And I didn't know about the whole strongman thing. Holy crap!
That's too funny. So yeah, it's just a great point on the big picture to understand more understanding the nature of the hustle and the cause of it too. But baby steps at a time, and just recognizing it at every step, because it is. And most people, this is to many people's detriment. They don't see, the only step that they see and fight on is when a cop actually has their hands on them and now it's wrestling. That is not the step that you want to draw the line and start fighting. And it's embedded into some cultures, and it's, again, to their detriment. Nobody follows that. And it's just... Go ahead.
Oh, sorry. But we also see people falling back at arraignment because they say, well, arraignment is just too tough to fight him there. I'm going to fall back and fight him at trial.
Oh,
because that's where all the advertisement goes to, fight him in court, get your day in court.
Mm-hmm.
You know what? I'm sorry, trial is not. They've already got that wrapped up to where it's it's super, super predetermined. Yeah, there are some folks who get through trial and come out the other side. I can't really think of anybody who, in recent memory, has convinced a jury to do squat.
Right.
Ethical, to err on the side of ethics. It's such a rarity that nationwide it's news when a jury actually does a nullification bid or something like that.
Oh yeah. Yeah, it's not a good bet to be looking at having to make. That's for sure. Not one I would want to make.
Yeah, with as many trials as are going on, the odds of getting a handful of people together who are going to have sympathy for a drug case or something like that is pretty decent.
Sure.
It's pretty decent to happen, to occur, not to be frequent by any stretch.
I would say though, what do you think about this? Let's just hypothetically say you get somebody for maybe because of lack of ability or lack of life situation, they can't. I know I'm painting a weird hypothetical here that doesn't really apply to any of us, but if someone were to be like, I don't have any time for this, I got this other thing going on in life, and I got to get out of this as soon as possible. I guess the question I want to make is, it seems that it would be more effective at minimizing the damage or threat of violence and punishment if a person were to, if they get steamrolled into accepting some kind of attorney or counsel of some form, to simply instruct that counsel to do nothing but threaten the jury. My point is that more effective at getting a better deal out of the prosecution than just letting a normal lawyer do his little BS and roll your dice and hopefully get the best plea deal you can finagle? This is desperate situations for people who can't fight we're talking about.
Right. I know. And we've seen folks that put up the whole to broadcast that they're going to challenge, that they're going to challenge the prosecutor to actually hold to do his work, right? And threatening a prosecutor that he's going to have to do his job is sometimes pretty effective. and then just saying, look, it's going to go.
I'm threatening
it's like
public.
My preference is just to do damage control.
Sure. The threat of public exposure. The jury is it's cost and it's public exposure, and it's a wild card for them. They never know 100%. They're only 98% sure they'll win, right?
They could get a judge with a conscience by accident that has somehow slipped through the cracks.
One person can hang a jury, right? That can happen every once in a blue moon. So I guess what I'm saying is that minimizing because obviously, Gary, some people are facing times and stretches where they can't fight like we do. It's just like minimize the damage. So are they better to...
There's so much minimization that can happen. But you show your teeth, perhaps? Is that what you're getting at? You show your teeth, you put in the motion to dismiss, you file motions about prosecutorial misconduct, the whole bit.
Yeah.
And then you come back and say, listen, I don't have time for this, you don't have time for this. What is it truly? What can we do as far as damage control goes?
Well...
And then just kind of like hoping for...
If you got the time to enter motions and fight the way we fight, then obviously do that. Forget jury and just do that.
No. I mean that initial set.
Yeah.
I mean, if someone's obviously facing something for real, the week it takes. I thought you meant a week is okay, but not, not months or something like that. The drawn out 30-some-odd arraignment attempts that we can end up in.
Oh yeah. No, it was an oddball question that doesn't come up very often. I didn't even need to spend much time on it. It was just, if you were rolling the dice, would you rather get a typical defense attorney to try and get you a good deal, or would you try and get a good deal by threatening the jury trial gas pedal all the way forward?
Oh, I see, the defense attorney route. Well, I mean, if you have, they have their standard offers, right?
Yeah, they do have standard
offers.
That
has nothing to do with what we're talking about. It's the standard offers and everything like that is just what it is. What is it you're saying? How would you leverage that?
Because depending on the case,
none of this can be leveraged with a lawyer.
Depending on the circumstances.
As a lawyer,
huh?
Sorry. Because the defense attorney instantly nixes everything that we're talking about doing. They'll instantly waive speedy trial. Just about. They'll instantly waive any challenges to jurisdiction. They'll take it as they'll take it as admitted that, there is jurisdiction and yada, 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 right?
Yeah. So
that's just the normal workings of the legal system, right?
Right. I just wonder if under certain circumstances, trying to force them to the expense, the time, and the public exposure of a jury trial would be getting you a better deal than just going with a lawyer for those in that situation. I mean, we've seen Robbie here get 8 hours of community service when they're saying if you don't obey, it's a year in jail.
I'm misunderstanding part of what you're saying. Let me try again.
Okay.
You mentioned that the plea deal by a public defender
or
versus
any defense attorney,
the expense and so forth of a trial.
I mean, it doesn't.
Maybe I'm misunderstanding the alternative. Do you mean how would you get to a plea deal other than the normal going to the defense attorney and saying, what are they offering us?
Well, even if you don't have an attorney, they'll offer you something. So basically saying, which is better, have the defense attorney and try for them to get you as good of a plea deal as possible, or do you think the plea deal is better if you threaten them with a jury trial and no attorney?
The funny thing, well, I would say for the quick draw thing, and I don't really have too much to really compare with. It's not like there's tons and tons of data, but with someone who is facing a bit, you're in jail and some bunch of money, filing the motions just to show your teeth.
Oh yeah.
Show that you've deconstructed their issue and that they have some work to do and they won't be able to make it by without doing their full work, which is the threat here. I mean, they're used to being able to skip so many steps in this.
Mm-hmm.
They almost skip all of them when someone's, pro se.
Sure.
They skip a whole bunch of them when someone has a public defender. And we're pointing out that, hey, you're going to have to dust off those books in theory, or fight, or hope your judge fights for you to keep you from having to do these things. And that can back them off quite a bit and get them into, I know, Troy. Troy went from whatever, and he just upright told them, he says, listen, I'm not going to spend a damn day in jail, and I'm not going to give you any money. What can you do? And they came up with like 8 hours of community service. And they were just like, at that point, it was one of those things where they're like, the week in jail, we're considered that the punishment and plus so many, $2,000 or whatever. I don't even remember the exact things, but they were acting like it was just a foregone conclusion that he'd be paying something.
Yeah.
And then it came down to the true, showing the cards, so to speak, and they had nothing. It just came down to, that's the wrong. I abused the analogy, I'm sorry, but you know what I meant.
Yeah. No, I guess I'm just putting it out there that, when people think they're up against, quote unquote, the government, no, you're up against some goofy prosecutor, potentially. And goofy decisions. So it's kind of something that you can kind of have more maybe control or in your hands than you think you have. And
showing, all these motions. I mean, again, it's not a huge investment. I guess it depends on what you're doing. If you're talking about a $50 ticket, and you don't want to learn this stuff, then don't pay pay the $50, not your $50, pay their $50 ransom. But if they're threatening you with time in jail, like, and they usually pull out the good double-digit numbers for anything. I mean, heck, I think jaywalking is probably a 30-day thing, if it's not just money. But, come out show some teeth, show that you can actually make his life miserable to where he's more interested in going after somebody else.
Yeah. There's a lot of different ways to skin the cat, so I'm just good to explore all of them, really, especially the ones people don't think of too often, I guess. But
right.
All right, cool. Let's push play here. Actually, you know what? I'm gonna push stop and then re-record because some odd things. If my power goes out, I'm gonna lose all this. I just want to make sure I get this locked and loaded.
Good point. Yep.
Okay, and we're off and going. So here's part 2. Here's a play button.
And
how would you like me to answer the question?
I'd like you to answer how you would like to answer.
Okay.
So here are the questions to go along with them turning in his waiver of counsel, right? Okay.
So am I being threatened with contempt if I answer honestly?
No, but I will let the decision that I ordered you to make was either appear on your behalf or you have a court attorney representative. I actually failed to evaluate the third option that you have, which is that you can have an attorney serve as your legal.
Could we stop here and maybe tell me what she's saying, because it seems like he's addressing exactly where I was pointing at earlier, where it's like, okay, is this now going off and beyond what you ordered me to do?
Yeah, he did. It was great. I haven't listened to this section going forward, so this is new to me. And he did.
Excellent. He was cognizant of that very problem.
Yeah.
And she seems to be dancing, and I'm trying to figure out exactly how, because she's moving around and trying to choose her words.
Well,
and trying to adjust her sentence mid-sentence.
Okay, so Robbie put it even...
So what did she say?
Well, he put it... I just want to point real quick first to his question, because it was just extra smart. It wasn't just, hey, is this... am I still under a threat of a cage? It was, am I still under threat of a cage for not answering honestly? So she kind of had to say no to that. And now if he just answers in a way she doesn't like, he can always fall back on, but it's honestly, and you said I wouldn't be threatened for that.
Right.
So I just like the way he set it up there.
But she's not telling him yes. She's trying to keep her threat in place. Right.
So I'll push play again and then let you know what she said. Unless you had something else.
No.
First. Okay. Here we go.
Have a court attorney representative. I actually failed to evaluate the third option.
I actually failed to advise you of a third option.
Which is that you can have an attorney serve as your legal advisor.
Which is that you can have an attorney serve as your legal advisor.
I
like this of an attorney.
Directly of his conversation about whether that attorney would need to be licensed by the opposition. She's trying to mitigate that answer, I bet. Is the way I'm kind of feeling about it.
Well, this is, of course, where she was, introducing, you remember how I just threatened your freedom 15 minutes ago with 2 options?
Right.
Actually, there was a third one I should have mentioned. I failed.
And one that is benign in comparison.
Right.
The idea that you can, you can have a standby counsel that doesn't have any plenary power or anything like that. That's a whole different, that is so far removed. That is just like what he was trying to get at, obviously, and she's bringing it up and not leaving him any time to consider the option.
And
right? She wanted to. Sorry.
I will mention that option also still comes with the threat, and I feel like she's trying to sell me on that option because, that would be a great option. Except if I were to take that option, then I would still have to fill out the waiver of counsel, which still on there.
Right. Right. It still gets that signature she wants because all of these things have the disclaimer. You signing away any right to be informed. Or not any right to be informed, but you basically abandoning the whole information idea is a side effect of all of these choices, right?
Sure.
Yep.
So I guess it could have been, okay, well, maybe it is going here. I don't know, but, there's a third option? Okay, crinkle up the one you just made, throw it to the side. What's the third option? I'll take that one. But as you put your hands up to the side like I surrender. I just have to accept that this guy's going to be my legal advisor, not full-on counsel. Okay, that's my third option. That's great. Do I have to sign anything or else I'll go to jail? What do I have to sign or else I'll go to jail? Do I have to sign this?
That's a minor. That's a minor plus over-representing yourself, right? Minor
plus over-representing yourself.
Over, to have a standby counsel of some sort is just.
Well, yeah, but of course I'm thinking of the motion that's coming in a week, the apology, that doesn't just include an apology for having to lie to the court on a permanent record, but an apology where you would have taken this third choice that would have been offered originally because it didn't involve actually signing away or agreeing to any kind of, throwing away the Fifth Amendment or assistance of counsel or whatnot. It was you could detail it out and further embarrass them by saying, not only did I have to lie, I had to pick something that on the time wasn't on the table, but if it was, I would have taken it. But the judge just, she failed. You know what I mean?
And you didn't have the time to consider and clarify.
Yeah, 15 minutes,
right?
TikTok.
And that's specifically what she gave you 0 time to consider this option.
Yeah. I was trying
right, wrong, or indifferent, you had no time to deliberate.
It was your intention.
It's called rush to judgment, and it's supposedly one of those big bad things that they're not supposed to do.
15-minute rush to judgment. While you're asking
No, this isn't 15. We're past 15. This option doesn't have 15 minutes to judgment. He does, between the thing he chose and this, he's getting 0 time to deliberate the thing.
Oh, yeah. Yeah.
You see. Yep. He had 15 minutes between the other 2 choices, and maybe if he'd have chosen the other way, she would have never mentioned.
Yeah.
But now here she's revealing something else because he chose B or whatever. Really manipulative, of course.
Yeah, so squirrely. It's so squirrely. It's just messy. Okay, here we go.
But you would still have to sign this document representing yourself as your primary.
Well, what I would like to have is assistance of counsel that is not licensed by state authority. And
I've explained to you that assistant counsel is not licensed by the state of Oregon.
So you're
failing that you disagree with my statement of what that is. Is that correct?
Well, do I have the right to assistance of counsel of my choosing?
If you not for the court, we would not pay for that.
Ooh.
Wait, say that again?
She said, do I have the right to the assistance of counsel of my choosing? And she says, yeah. And she says, we won't pay for that. But she doesn't deny.
That's fine.
Right. Okay.
Right. And so Mark would be fine?
Huh?
And
I mean, the true thing is that she's She's just looking to get her paper signed, right? That's the real goal.
Of course, of course.
Right? The exchange she's offering is this assistance of counsel thing. But I tell you what, if you try to bring in, your best friend, I bet you she'll have a flip about it, right?
Well, yeah. What was the scene going on here, Robbie? What were you going to say?